I work in New Hampshire and Goffstown. It's on just the other side of Manchester.
Unfortunately, we have to have another abbreviated class because I have a trustees meeting at 5 o'clock by conference call, so I apologize. Unfortunately, it's a very short week, but.
That's very sad.
Yeah, well, you can all stay and continue to discuss the cases.
What are we talking about the refund?
That's right. Well, I could just give you some projects instead. Or you could always stay and talk about them yourselves. You realize that, right? Let's take a quick look at them. We're in section 7, but you actually could if you wanted, because I do enjoy these cases. Bradley versus Fidelity is, I think it's another one of these interesting cases, and I want to ask you a little bit about some of what's going on there. And what's, I think, interesting in part to it is this is one of the few cases where you actually see that 176D can be used by someone other than the insured themselves. So this is used by someone who isn't in privity of contract with the insurer, and it makes it kind of a unique application of it. I also happen to like the case because I know the lawyers involved. I know one of them really well because when I was a lawyer in Boston, we used to try cases with each other a lot because we both represented the Boston Teachers Union. When there were conflicts, he would have the other side. So we actually had a lot of cases. We had a lot of cases together. And actually, some of what I want to ask you about is his behavior in the case. Melanie, did you have a question you started to?
Well, yeah, I apparently have been voted to ask a question.
Okay.
How much detail are you looking for in the answers to those questions that you post online? Like, are you looking for pages?
Usually, most people answer the week's worth of questions in a couple pages.
Okay.
Each question doesn't require a couple pages, but I think the week's question generally will be. It shouldn't be a sentence or two because I think there's a lot more that you should be thinking about and working through.
Okay.
And you know, frankly, if there are, and I think occasionally there's a question that probably could be covered in a simple paragraph. That's fine too. I don't expect you to fill a page if you have nothing of value to say, knowing you always have something of value to say, Melanie. But that's really, you know, I mean, use your best judgment. I'm just not looking for you to fill pages just because you can fill. I'm looking for you to extract the information from the case that I think is important that you should be getting. So, again, take a look. You really, if you're thinking of going that route, take a look at the questions first because they're no rocket science in there. It's just, you've read the cases at this point. I can tell that from our discussions. Now, you're going to probably have to go back through the cases and pull some of that information out if you haven't already done it for an outline, which then that would also mean it's a pretty good thing to do for both the midterm and the final anyway, right? So you use your best judgment. I don't have a decision either way because I'm going to evaluate what you sent in, but you're the one that has to decide which way you want to approach it. So it's really up to you guys. Okay? Were there other questions related to that?
No.
So why did you have to vote her to do it? Because it's you guys have a
It
question.
was one of those somebody needs to ask, so.
So who else would it be? No, but whatever. Okay, if you guys have questions, though, right? Just ask. Let's talk a little bit about Bradley because I really did enjoy this one. I also enjoyed this lawyer, Hans Haley. I told you I used to have a lot of cases with, and when I was a very young attorney, I had just gotten out of law school. We had a lot of cases together, and he uses a wheelchair to get around. And what's interesting about it is, you know, if you thought that because of the wheelchair he has limitations, no one could use that wheelchair like he could. And he would frequently maneuver it in such a way that as a 25-year-old attorney, I was looking like a jerk because he would he would use everything he did within the courthouse, and how we practice law against each other in a highly skilled fashion. And so I could imagine that you guys may come across people that you don't think are as skilled as you, or as capable as you, or know what they're doing as well. And I can tell you from experience that that would be a bad mistake, to necessarily judge people just until you really work with them. Because trust me, he could outmaneuver most attorneys that I worked with on a regular basis. And it was fun, because I think as a young lawyer, he schooled me a lot, and he would tell me things like, I would read a case, and that's why I'm going to tell you this story, because I think it's important for you to recognize it too. He would tell me, I would tell him, Hans, I've got this case, you know, you're going to have to resolve it, because this case is absolutely for me. And it was absolutely for me, absolutely foursquare for me. He would be able to tell me with a straight face that I completely misread the case, that it is of no value to you, and not only is it of no value to you, it really helps me. And therefore, we really need to go back and recheck it, Mike. And you know, we call each other Mike and Hans. It was a good relationship, but tension-filled nonetheless. And I think that's the other part of it. I think you can have good relationships with your adversaries, and testy ones at times, because that's the nature of our relationship, but nonetheless like and admire your advocate, while but still being respectful. And the reason I'm telling you this, because I think as a young lawyer, you know, you even, sometimes, especially if someone is older than you, you start to doubt, well, okay, maybe I misread it, maybe I'm wrong. But you, at some point, have to have confidence in yourself that, no, I know what I'm doing here. And, you know, we worked against each other for so long that you became adept at figuring out his little tricks and the games and all the rest of it, so that you're a little more wary as time went on. I remember we tried a case out actually at BU. We tried it in one of their courtrooms, and then we settled it probably at the end of the second day of trial. And he said, Mike, you write up the agreement. My hands hurt from the chair, remember? He said, my hand hurts, I just can't do it today. And I'm thinking, that's okay. I know exactly what this game is at this point. So then if there's a problem with this agreement that we're writing out at 3:45 to resolve a case that got all the way through the second day of trial, that it's Mike's fault, because Mike's the scrivener, right? I mean, you remember that from your days in law school. And I'm sitting there saying, okay, how do you say no? You write it. Right? Because I know what the deal is here, but so you can't, right? At the end of the day, you can't. But you can make sure we both check it very carefully, and you know, maybe get them to add a little thing, so maybe we can at least argue we're both the scriveners. But the point is, you end up dotting your I's and crossing your T's, and you don't, even when the relationship is testy and challenging at times, it doesn't mean you have to not be professional and not really like one another, even though you know that there's, because I've seen them at the AAJ trials more recently, and we have a great relationship, but as adversaries, if you understand what I mean. Go ahead.
Do you feel that the sense of professionalism between adversaries, between lawyers today, is dissipating and it's becoming more hostile?
Yes.
As opposed to what it used to be?
Yeah, I do. I think there's a greater, I think judges are probably nicer to you than when the judges, when I was first in college, when I used to go to court with lawyers, or when I first became a lawyer, the judges are much better. They worry about, you know, the I-team and the TV stations doing exposés on them. So you don't get, when I first became a lawyer, when I was in college, going to some of the courtrooms, you would see judges that were just brutal with advocates, especially new advocates. And even back then, not that I graduated in the dark ages, but women advocates, because just even in '83, there weren't as many. In law school, there were at that point, but there haven't been that many female lawyers out practicing. And some judges were especially brutal with young lawyers, and there were some that I thought were definitely sexist as well in a lot of their comments and the manner in which they conducted themselves. That, for the most part, is gone. I think what's happened over the last 30 years, not to the most part, I mean, there's obviously still, you're going to face hostility at times for various reasons. But I think the practice of law in part has at times gotten a little more challenging from the standpoint of having to make money, keep clients, and plug out all the work, that I think some of that civility that we expect and we should encourage and you should have it's not as comfortable all the time. But even early, but as I'm telling you the story with Hans, there were other lawyers as well, and much worse. I mean, not just much worse. There were lawyers that I really despised that I had to work against, that you wouldn't trust at all, even all the time. I do worry that there may be more at this point that you're going to face. That's why, even more so, why you have to conduct yourself and be careful. But yeah, hopefully you'll have fun with it, because it can nonetheless be a lot of fun. We had a lot of fun, nonetheless being wary. I want to ask you about what goes on in this Brandley case, because how much has he asked for originally?
$1 million.
Is it $1 million?
$1.4 million.
$1.04 million. And how much has he ultimately settled for?
90,000.
I don't think it was as high as 104, was it?
84.
No. Is that what he settled for, the case? Not what the 176D award was. How much did he ultimately get after things got all sort of squared away? It says here, the two claims ultimately settled for a lump sum of 84 grand. So he asked for $1.4 million, and he settles for 84. Less than 10 cents on the buck. What do you think about that? I mean, I have an adage that I tend to use, that if you don't, especially in the legal profession, if you don't ask, you don't get, right? You don't ask for something, you'll never get that. So is that consistent? Is that just all he was doing? What the hell, I'll ask for $1 million and they give it to me, shame on them? Or doesn't there seem something not quite right about that? But so what's the deal with that? Because he argues, and I could hear him making the argument as well, is later on in the case he says, well, there's no, 176D doesn't regulate my behavior. It doesn't require me to be reasonable at all. It requires the insurance carrier to be reasonable. Right? That's his argument. Could you make that argument with a straight face? But and by the way, I could absolutely see him saying just that as the court correctly quotes him. Right? I don't have to be reasonable, they do. That's, you'd be comfortable advancing that argument? Because I could see where, I can see an awful lot of judges.
I think it attacks the credibility of this claim. He's coming in there with $1 million. Once he settles for 84, it becomes obvious in retrospect that he had no basis for the original $1 million to begin with. And in the meantime, saying, well, I can do whatever I want because I don't have to be accountable. I mean, that's not what it's about.
But he gets away with it, doesn't he? Because what do they do with that $1 million demand? They do nothing, right? So I get this, what I perceive as a wacky demand that has no basis in fact, and I ignore it as the insurance carrier. Can the insurance carrier just simply ignore the demand under those circumstances? John?
It has to, I think there's one of the things that says that they have to keep a record of every demand. They can't just, so they, in this case they didn't respond to a bunch of the initial things and then didn't even respond to the 93A demand letter for a while.
Well, for a while? Or
Within the 30 days.
Oh, okay, fair enough. Within the time period to respond, they in essence do just simply ignore it. They don't respond within 30. By the way, though, he doesn't follow up either, right? So then, what?
No, I just said that he did not follow up for almost a year and a half.
Right? So he does nothing in the interim, and the thing just sort of sits there. And then when he finally does pull the file out again, at some point, they get to be reasonable about it, and as they're looking at the actual values of the case, that's how they arrive at the $84,000 figure. They look at it, and at some point, significantly after the demand was ever made, they ultimately are able to resolve it. It says, there's a memo here that says 5 months after the initial demand of $1 million counsel forwards a 93A letter with a demand for $990. So he becomes infinitely more reasonable by dropping his demand to only $990,000. And that's the one I think ultimately that triggers some type of response. What must the insurance company do, even with what they perceive as a ridiculous demand to try and resolve the case? Under 176D, what do they have to do?
Offer to settle.
Well, at least they have to acknowledge the demand, right? Go ahead.
I have a question for you. So at the end, they only got double rather than triple. Do you think that that was influenced by the fact that he asked that much in the beginning?
Yeah, I think it's influenced by a whole bunch. The sort of the delay on his own, this argument that, but correctly so, that he doesn't have to be reasonable. 176D and 93A don't regulate his activity. They regulate the lawyers. The insurance carriers. But the court always has the ability to determine how egregious the violation is, and it doesn't have to be treble. The fact is, the likelihood is, if we research this, we'd find more often it's a double damage award as opposed to treble. So it's not automatically jumps to 3 just because it happened. The court looks at how egregious the error was to decide whether it warrants the treble as opposed to double.
But this certainly could have weighed on the fact.
Oh, absolutely. I think the whole thing here is, we're looking at the insurance company has to be reasonable no matter what, right? Because he makes the argument that I don't have to be reasonable, they do. And the court says he's right in that regard, right? In fact, he is right, because this doesn't regulate his activity. Now, there is note 7 here that I want you to be aware of. It's the point I started this discussion with. You're going to have trouble locating some cases which talk about 176D as being available to someone other than the insured, other than the person that's contracted with the insurance carrier. Here, what they did is this was the person whose settlement was delayed. They then asserted the claim against the carrier. What sometimes is done in these cases is if there's the delay, if there's the failure to settle reasonably, and then there becomes this award at the end from the insured, you might settle with the insured and have them assign those contract rights to you as part of the settlement. And then at that point, since you have the assignment under the contract, then at that point you can pursue the action against the insurance carrier. That wasn't done here either. This is a direct action by the non-insured against the carrier. At the end of the day, what does he get for their failure, their violation of the statute? Because it says the Brandley's actual damages include the $84,000 settlement as well as lost interest. And then the question is, how big should the multiplier be? Because there does appear to be willful and knowing violations of 93A. They ignored numerous communications, right? And the fact is, they want their costs, their fees, and that's what they're going to submit as well here, is it's not just the double damages for the difference. It also will include the attorney's fees for prosecuting the second action. And so that really becomes a game changer in many ways under the circumstances. And the fact is that they will be entitled to that as an additional element of their damages. now I want you to notice something that I think was unusual about the case, but it's not that unusual in practice. I gave you the note that after this decision came out, there was a settlement of the case, and at that point, the insurance carrier asked for reconsideration, and based on that request, the parties then settled the case, and the decision is vacated and withdrawn. An incredibly unusual set of circumstances. I think what they really did here is they bought his silence. The insurance carrier didn't want this case to serve as precedent because it's an unusual case where the insured is not the party bringing the action. And so what I mean to point out to you here is that, you know, when we get to trial, that doesn't mean that we then have to wait till the judgment's entered and all the rest of it. There are still means of settling post-trial, and in this case, I imagine they paid a premium to settle, to have the decision vacated and withdrawn. And the other part of it is just because you recover a judgment doesn't mean you automatically get paid. The case is going to go on appeal, and at that point, you might be waiting years still to receive any compensation. If you've got an insurance carrier like this that's the pocket, you don't worry necessarily about recouping those damages and being able to collect in 2 or 3 years' time. But there are probably banks and other companies, people thought that was true. And as it turned out, in a year's time or less, people's financial condition can change significantly. We've got one more to look at, and this is this Kaplan case versus Feldheimer, Eichen, Braverman, and Caskey. And it's an interesting case because here the insurance company wants to settle within policy. It won't cost the insured a dime, with the following caveat that he appears to have a counterclaim filed. But the insured says, I don't want you to settle. And I don't want you to settle at the minimum. Did he want the apology, right? So don't settle unless you get an apology from her and retracting, in essence, her claims. So that's my first question. Would you encourage your client to apologize and retract their claims, even if their claims are true, if the number is right? Did you say, mm-hmm, Fiona? That's what it sounded like, right?
I guess
The number has to be really right.
Yeah,
So okay. As long as the number's high enough, you need to do what you need. Would you tell them to lie though?
I still feel uncomfortable telling them to do that though, because
I want you to apologize for bringing these baseless accusations that I
You could,
grabbed your butt. Did he grab your butt?
apology.
Yes, he did. Just say though it didn't happen.
You could give an apology without apologizing.
What's that mean?
You could say something publicly to satisfy them without really saying, I'm really sorry.
Okay, so we'll just work out the
Just-
language.
yeah, just a-
We'll withdraw our suit. We'll say, well, you're sorry,
Not really.
but you're going to say it?
You would say words, I guess, would create that effect.
Well, what's that
Not
mean, though?
saying-
Words that will create that effect? Because this happens on occasion. I want them to say their claim is baseless. They're not going to say it's baseless, right? And by the way, sometimes people say, I'll say whatever I need. Just give me the $1 million check, right? Right? I mean,
That's true.
so maybe then it's not an act of conscience, but is it still an act of conscience for you? Because I'll say whatever they want. If they write the check out for enough zeros, I'll say what they want. But, so are you still in then? Or are you going to say, I can't be part of this?
I think if the client is okay with it and that's what they want that it's more about the money for them than
Yep.
the image, if you will, then fine. Who am I to sit there and say, oh, you shouldn't do that, that's not morally correct. You know what I mean? Or
So if they want to do it,
if they want to do it, do it.
and you're going to protect them so they can't be sued later on for whatever, and you're going to take your third. I assume, right? You're not, right? So, I mean, you're not so offended by all of it. Because, I mean, one way to approach this, we could have gone back to her and said, can't you just say it was a mistake? And, you shouldn't have done it, and you apologize for bringing these baseless accusations. And I would imagine, under this circuit, many plaintiffs would say, I will never say that. Some will say, I'll never say that. But let's be honest, we say it for 50 grand more. We say, no, right, we say it for 100 more. The likelihood is there is a number with which we're going to say it, or your client will. And that's what I do wonder. I mean, is it just like Fiona said, is we'll work out the language? Because we can do that. And I did have one time where they wanted to say, well, the claim was baseless. No, it wasn't baseless. It was, well, the only reason you're settling is because we would have won. And, you know, we don't have to say that. You know, but so we'll work out language that says it would have been difficult to prove his claims at trial. It's difficult, but I still would have won. I just won't add that part, right? So is that okay? So we'll do what lawyers do. We'll put together language that sounds, well, he didn't do that. I'm sorry it came to this. Our claims would have been difficult to prove at trial. Can you sign off on that? Because I am sorry it came to this. I would have preferred to get the money 3 years ago. No, is that's what we're doing? Go ahead.
I don't think I would use apologetic language like that. I don't think.
No,
I
oh,
would
but
use
okay.
sorry.
I'm not writing a check unless you do. I need to see the word sorry in there. I don't care how you put it in. So that's the
You didn't
question.
say sorry for the circumstances.
Okay, so you'll say sorry for the circumstances. That may be good enough. Sorry for the circumstances, I put you in. Will you say that?
I what?
I'm sorry for the circumstances, I put the defendant in.
No.
I'm sorry my relationship with the defendant ended in this manner.
So you're making something, that sounds better.
I might be able to live with that, because that sounds like you did some sort of little personal vendetta then. All right, I might be able to take that back, but we're all going to sort of work the language out, even though we know it's not really true. Because all he wants is an apology. He wants to save face to all his colleagues in Philadelphia. And he's not going to let her settle otherwise. That's what he says, right?
But he has to feel very strongly about that to risk that. Thus, what I would
Well, maybe he
suggest
just thinks,
that he's got.
I can win.
Well, maybe he can win. Maybe
No, I can win because I can beat you up before you, this has to be pretty hard to advance a claim against a law firm to sue them for sexual harassment. We're lawyers, okay? We eat our young. Bring it on.
Well, it's sort of like the argument, there are two sides to every story, and the truth is somewhere in the middle. So that's how I would approach it with my client.
Which means,
Which means that he has an argument as well. No, he doesn't see it your way, but there is another way to see this.
okay, but so what
So that's why I would, urge my client to accept the $1 million.
So you'd tell her to say
And-
she's sorry? To
Well, but I
withdraw?
think she could couch it in other terms besides saying I'm sorry. She could say, I liked what Fred said.
What was it, Fred?
I'm sorry our relationship ended in this manner, or something like that.
Unfortunately,
With that, so you had some sort of relationship with the defendant. No, that's what it implies. Almost a consensual relationship. Geneva shaking right, Geneva, no.
I would say what she said at the beginning, that I would let my client make that decision. If my client's okay with the amount of money and they have no problem apologizing, then that's fine.
What would you say if they asked you the question that they often do? What would you do?
I would probably take the money.
Personal satisfaction.
Fair. Well, listen, let's be realistic. A lot of people would, and if the number is big enough, it's very difficult to say. We can sit here, it's nice, it's a classroom.
Well, we also know we might not win.
And you
Right,
know you
so
may
why
not
wouldn't you
win,
take
but
it?
you also, in some of these cases, and again, we're sitting here, it's a rather sterile environment, we had a good lunch and we're gonna have a nice dinner. I had one, we settled last year, and I, honest to God, do not know how he held out for as long as he did. But he was a very, very brave individual. But I can tell you, I'm not gonna tell you the stories at the end as to how bad it got for him financially and personally, but it did, real bad. But he told the line to the end. And that's not easy for everyone, right? You lose, at some point you have no money left, you have no family to tap into, you have no resources, And especially, I mean, look what he did here is that, you know, the best defense is a good offense, so she files suit. And he brings counterclaims for malicious abuse of process, civil conspiracy to abuse process, and
They were dismissed.
well, they were dismissed, but then he was able to keep the malicious prosecution alive somehow, because the only reason really that he gets to argue that they shouldn't be settling is because he's got the counterclaim of some sort that means if they settle over his objections, what that means is then that he's potentially losing his claims to malicious prosecution and the like. So it's a very unusual case when you think about it, because normally a defendant wants to be free and out from any further exposure. But here, he wants to prevent them from settling, use their resources to help move the case along, and wants something more from her. And as crazy as it sometimes sounds, the feelings in litigation matter for some of these parties, and that maybe is difficult to work around as trying to figure out the number and you know, the other terms of the settlement that are important. It doesn't happen a lot, but it does come up with, well, so what do we do? And the other part of it is that you need to think about sometimes in resolving them is the notion of, well, what if they want the information back? What if they want you to destroy the information that you received as part of it? You know, someone was settling the Ford Explorer cases early on, knowing those tires were exploding and injuring people, and not disclosing any of that information to anyone as part of the confidentiality that Ford demanded. You do that? No. No? But you have a client whose interest it is in to settle that case and get a big number, and in part, pay you for your silence. Right?
But you can't destroy documents.
Well, so what will you return everything you've got to me? And if not, why not? Right? Why can't you return the stuff we gave you? You've got lots of discovery proving we did really bad things. As part of the settlement, we want it all back. And by the way, I've had the same situation as you. They asked to return them, asked to destroy them, and I said, I won't destroy them. I will return the information you've given to us, and you can, you know, if you're going to do something with them, that's up to you. I'm not destroying information that I've received. So sometimes that becomes part of it. From this standpoint, on the insurance issue, can the insurance company settle over their insurance objections, even though at least the insured isn't then subject to any further exposure? No. No, right? They've got an obligation and a fiduciary obligation to work with him. And see, I read this case and I think he's just full of spite, and he's trying to use his leverage. And the court really doesn't help out that way. They say, well, it's still part of the case, and they can't settle over his objection.
I thought at one time in this case they were about $10,000 away from settling.
Yeah, 190 to 200 or something, right? Right.
So in that sense, it seemed like the insurance company kind of undercut them when they. I think the two parties were close to settling, and she was going to give some sort of retraction.
Was she? See, I think he demanded the public retraction, and that's where it all broke apart. Because they were at the number of 190, right? And then where did I saw the 200? At some point, where are you at 200? Wait, didn't we have it? Oh, there it is. So if you look at it, the number was 190. He wanted a public retraction. They said, Judge, can we meet? Maybe you can put the hammer on us here because we're awful close. And then then there was a settlement conference. And while there, they continued the discussion between themselves without Braverman, The number then got to 200. The plaintiff executed the release in a stipulation of dismissal for the 200. And then that's where he said, whoa, 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 wait a minute, what happened to my retraction? Because that's what he wanted. I don't think she ever agreed to any form of retraction, and that's where everything broke down. It wasn't a question of numbers anymore. He's not getting what he demanded as part of it to try and restore his name in the legal community. And the fact is, you know, there'd be many people who would, I don't care what for 200 grand, you know, tell me what you want me to say. I think it's impressive that she was not prepared to retract her claims. The question then though becomes, is there some way that you could have resolved it, or at least found language that everyone could live with? I got to run down to this meeting, but what I would suggest in that regard is what we talked about. There may be language, it's distasteful as it may be, there may be limit. She's not going to retract her claims completely, but maybe there's language that everyone can live with. And so especially when you're that close, don't just walk away because you don't think there's any way to solve it. You guys end up being wordsmiths. You should be able to figure out a solution. Because you are lawyers, you can use those reasoning words and work it out.
Section 8.
Yeah, Section 8. And that's right. And then remember Thursday you're going to be doing the injunction, so complaint. So you've got to